Welcome to the third tutorial key points video. Now, because of the bad weather this weekend, many of you weren't able to get to the tutorials, so what I've done is, for this occasion only, instead of just a single tutorial key points videos, I'm actually making 4 videos. This one where I deal with the general issues, a second one specifically on ETMAs and how to get the best marks in those, a third one previewing UK constitutional law, and fourthly then some comments on TMA 02 and 03. So to deal with the general points, we started off by looking at TMA 01, and as I say, I'll give some general comments on TMAs in a separate video. The points to highlight are that there is a pyramid, and at the top the word laws. When we use the word laws, we tend to think of it in 2 forms: legislation and case law. And legislation itself can be subdivided into primary legislation, also known as statutes or Acts of Parliament, and the division into secondary legislation. And secondary legislation itself can then be divided into statutory instruments, orders in council, bylaws, courts rules, various other rules that Parliament has delegated the power to make the detailed rules to. It's useful to know the stages that a bill has to go through in the normal legislative process, and there's an excellent interactive session on the www.parliament.uk website under bills, which takes you through the various stages and their purposes. Now, I'm not looking for you to memorise the different readings. I am looking for you to be able to explain the purpose of the second reading, of the committee stage, of report stage, and of third reading, and to make the point that both houses have to go through those stages, and of course that bills can start in either house. Another issue that is worth looking into perhaps in more detail is the scrutiny of secondary legislation. A number of you picked up from the textbook about the number of statutory instruments relative to the number of statutes. Well, some of those are very detailed, some of those aren't detailed at all, and ask yourself the question, what kind of scrutiny is necessary? Does every piece of secondary legislation need the detailed scrutiny that it should be getting in if it were a primary piece of legislation? Second question was about the differences between criminal and civil law, and it would be a very useful thing to do for revision for your exams, to make up a table, one column being criminal, one being civil, and listing, compare and contrast, whether it be the purpose, whether it be the procedures, whether it be the parties, the language, but build up quite a detailed table of those distinctions between criminal and civil. Point about that question is that in the advice and answering questions, it asks you to deal with the misunderstandings that need addressing from the email. Again, that needed to be done. This wasn't meant to be just a comparison. You needed to tackle those misunderstandings, particularly that understanding about being tried twice for the same offence. An offence is only appropriate for criminal law. I'll talk in the separate video on TMAs about the different levels that we're looking for. The other things we did in the tutorial were the role of lay people within the legal system. Do make sure that you can put forward arguments for and against and come to a reasoned conclusion on the value of having lay people in the judicial system, whether it be magistrates or juries, or the question you'd rather not have, discuss lay people generally, in which case it is both magistrates and lay. So do think about those arguments, and you'll see them in newspapers. There's lots of material to be found about that. We then moved on to the next section after we finished English legal system. You're going to do a couple of weeks on principles of UK constitutional law, and I'm doing a separate video on that. The principles of human rights. Now, the key thing to get into your mind is the distinction between the traditional English approach, the we are free to do anything we want as long as it's not forbidden, and the modern approach, which is there are certain rights that need protecting, and the law needs to protect them from all comers. And sometimes it will involve balancing different rights, because my right to say what I feel may interfere with your right not to have lies told about you, or your privacy to be interfered with. So balancing and protecting rights need to be considered. Another table that you can do, which will be very useful, is one which looks at the various rights that people have prior to arrest, at arrest, being taken to the police station, and whilst in detention. And PACE and the codes of practice give you the details, and I think this is something really worth spending some time on. It'll be important for a future TMA, but it'll also be useful for revision purposes, and I will be sending out a handout which gives you a possible framework to this. But you need to have a table which sets out what the right is, what's the statutory provision behind it, any relevant cases, any qualifications on that right, and what factors will bring those qualifications into effect. Then you move on to principles of criminal law, and the key things to concentrate here are every offence has a definition, either in common law or more commonly now in statute. And it's looking at that definition and discerning what are the elements of things that are done, the actus reus, the guilty act, and what things you need to look at the state of mind of the individual. So in a case like murder, the actus reus is the killing of somebody without legal authority. The mental element of it is that there has to be an intention either to kill or to cause grievous bodily harm. If that intention is missing, they may have been as reckless as can be possible, but it has to, for the offence of murder, has to be an intention to do those two specific things. So do look at that. As I say, I will be making separate videos on other subjects, including ones on TMAs 2 and 3. Thank you.